In 1791, the Fifth Amendment was added to the Constitution, whereupon it became the law of the land that no person shall be compelled in any criminal case to be a witness against himself. In the 221 years since then, no former president of the United States has ever refused to answer a question under oath citing the Fifth Amendment. Jimmy Carter has had the longest post-presidency of any president. He has lived 41 years now as an ex-president who, like Donald Trump, ran a family business before getting into politics. And not once has Jimmy Carter used the Fifth Amendment to protect himself from being charged with a crime in an investigation of his family business. Donald Trump only made it to the second year of his post-presidency when he decided today that he could not answer a single question put to him by the New York State Attorney General in a deposition because the answer could incriminate him. Donald Trump pleaded the Fifth Amendment to more than 440 questions asked of him in 4 hours. 440 times Donald Trump cited the Fifth Amendment.
The mob takes the Fifth. If you're innocent, why are you taking the Fifth Amendment?
Andrew Weissman is back with us. Can you answer Donald Trump's question? He's asking, if you're innocent, why do you take the Fifth Amendment?
So I think it's very important to remember that the Fifth Amendment and the assertion of the Fifth Amendment is a constitutional right that we all enjoy, and it cannot be used against you in a criminal case, meaning that we can't sit around and say, oh, the person must be guilty because they asserted the Fifth Amendment. That would be the case if we were all jurors in a criminal case, but we're not. We're public citizens, and in fact, in a civil case, the assertion of the Fifth Amendment can be used against you. And in fact, the very definition of asserting the Fifth Amendment is that it has to be the case that a truthful answer to the question would tend to incriminate you. That's the standard for asserting the Fifth Amendment. So by definition, it is a sign of guilt. It's just that under the law, it cannot be used in a criminal case. So the president is right when he says that many people, I wouldn't say all, but many people who assert the Fifth Amendment do, in fact, have something to hide. And that's one of the reasons that in a civil context, it can be used against you. But it is important to remember there are situations where somebody could be entirely innocent and they assert the Fifth Amendment because they're concerned about other things that could come out. They're concerned about a gray area in the law. There are circumstances where that does come up.
And just to clarify, the Fifth Amendment is a protection against criminal charges. For example, this is a civil case that he's testifying in. And in a civil case, he's going to end up with fines. There's no possibility of any kind of prison term or anything, any criminal liability in a civil case. And so in a lawsuit, if someone invokes the Fifth Amendment, they can't do it just because the answer will somehow hurt their position in the lawsuit, right? It's that they can only use the Fifth Amendment because it may hurt their position in the lawsuit or it might not. But what it will really do is create a criminal liability for them.
That's absolutely right. The Fifth Amendment, the requirement is that it would tend to incriminate you in a criminal matter. It can't be that you just think it will hurt you in that civil case. And so that is what's required in actually to have a valid invocation of the Fifth Amendment. Here, Letitia James, the New York Attorney General, is going to be able to get an adverse inference if she brings her case. She's going to be able to say, I want an adverse inference against Donald Trump on each and every question as to which he asserted the Fifth Amendment. And that means that the jury can assume that the answer that the former president would have given would have been adverse to the president on those questions.
So an example of a Fifth Amendment question in a deposition like this would be, isn't it a fact that you lied about the valuation of that property on this document right here on this line? And Donald Trump says Fifth Amendment. And then when you're presenting that to a jury later, what the jury is hearing is he was asked if he lied about the valuation and he wouldn't answer the question. And we have a right to make take a negative inference from that.
Absolutely. And the claim there is that when he was seeking loans from banks, he was inflating his assets and trying to look healthier as a business in order to get those loans. And conversely, when he was paying his taxes, he was saying he was a lot worse shape. So he was paying a lot less to the state and the federal government in his taxes. And if those questions are asked and the Fifth Amendment is asserted to those, the jury is going to be able to draw a negative inference against the former president. Having said that, Lawrence, if I were his defense lawyer, that's exactly what I would want him to have done today, is to assert the Fifth Amendment. He's in so much legal jeopardy that is the right thing for him to have done it from a legal perspective, maybe not from a political perspective, but certainly from a legal perspective. And this is an example of, people think that the former president is, not controlled and isn't that sort of street smart. But when you think about what he's done, he didn't testify before the special counsel. He refused to come into an interview. He did not submit any statements to Congress in the impeachment hearings. He has now not testified in the New York Attorney General investigation. All of those things are very smart because those are all jurisdictions where if he actually spoke and submitted a statement and they were false, there is criminal exposure for doing that. So he has shown remarkable restraint, and I'm sure his defense counsel is very happy with the fact that he asserted the Fifth today.